Next, from Springfield, we talked to attorney Aaron Maduff, who previously successfully defended state workers in their lawsuit against the state over pension reform. We'll get Mr. Maduff's thoughts on new legislation aimed at reforming pensions. This runs about 10 minutes.
The time value of money, is there a way to structure a deal, whether it's in this legislation, or is this let's stay with this legislation. Is this legislation proposing anything that would offer a valid incentive so that we might say, we'll give you money up front right now, and we're going to, if you agree to that, we'll lower, make some changes that'll save us the state money, but we're going to give you some incentive up front. Is there any kind of approach along those lines?
Let me back up for a second here, because I think where we should have started this interview in the first place is that the bill that is there is unconstitutional, and we will challenge it if it should pass into law. And I can go into the reasons that it's unconstitutional. Now, you've asked, is there a way to do a consideration-based deal that can do that? And there is one that's been pointed out, but it goes to effectively the time value of money. If you want to say to somebody, look, you have X dollars in the system right now. I'll give you 75% of it in cash right now. Take that money and go invest it how you want, and you're out of a pension. Somebody might choose to take that. That's conceivable. You're going to have a short-term outflow of money for it from the pension system, but that could potentially have some effect down the road if people are free to make that choice. Some of them will, some of them won't. But I think that here we have a situation where we have two verbatim bills that are put up, and that's not what they do. Let's talk about these bills, if I may, and why these bills are unconstitutional, and why SUAA is going to file a suit to hold them unconstitutional if they were to pass and become law. The first thing is that it says you have a choice. You're a Tier 1 employee, you're a Tier 2 employee. You have a choice. You can agree to not be getting AAIs until age 67 or 5 years after you retire, whichever is earlier. And it's non-compounded from now on. And your AAI is calculated at 3% or 1/2 of the CPI, whichever is less. So you can take that diminishment if you'd like, or you can keep things exactly as they are, except that you go further in the bill and it says from now on, anybody who kept things exactly as they are, if you get a salary increase or a pay increase of any kind, you agree that it is not pensionable. Well, that's not consideration-based. You've just stuck a penalty on there. If it was a matter of you can choose to accept our deal or not accept our deal, then you've got a legitimate offer to renegotiate. As a practical matter, I can't imagine why anybody would accept that deal. I think they would rather say, I'd rather keep it the way it is. But the way they're going to do it is they're going to put in this penalty. But when they put in this penalty, they are now changing the rules on you. That's unconstitutional. Now, the theory behind it is, well, we as the employer do not have to give a raise. That's their thinking. So certainly we're free to say we're not going to give you a raise unless you agree that the raise is not pensionable. And they're going to do that only to the people who say, I want to keep it the same. If you take the diminishments, then all of your raises are going to be pensionable. We promise it. Well, first of all, why would I take that when you're already saying you don't have to give me a raise? But here's the thing. Sometimes those increases are required. I mean, let's take a look at some of the situations we have here. If you get a promotion, you might move into a different grade level. That could cause an increase. The grade levels may change because of the CPI. How about a union collective bargaining agreement? The union goes in and negotiates, and they negotiate a raise, but now what the employer says, well, we're going to give the raise to some people you negotiated for, but others who said, we insisted it be pensionable, we're not giving them the raise at all. Well, now, has the union gone in and only represented some people and not others? Are we going to end up with a situation where we're filing duty of fair representation claims against unions? I think that the unions are not going to want to get into that. They're going to create a situation where the unions are going to have difficulty engaging in collective bargaining. And this bill, as it stands, actually has a section that would prohibit the state from negotiating pensions themselves. We're not talking about the salaries here, but the pensions themselves with the unions. And let me give you another example that really jumps out at me. And that is what happens when somebody's income has to go up because of the law, because of a minimum wage increase, because they've been working overtime, and under the Fair Labor Standards Act, they have to get time and a half for hours worked? What about the situation where what we're really saying is that your pensionable salary is really figured as how much you made in a given year? And if you're an hourly employee and you work more hours in a given year, you're going to make more in that year. Are we suddenly going to say, well, except that you're not allowed to have that pensionable? You say, absolutely, any raise I get is pensionable. I'm not agreeing to this. Well, then we're not going to pay you? Okay, so now we've got the state in a situation where it's not going to pay people for time worked, not going to pay people for overtime premiums. That runs afoul of the Fair Labor Standards Act. It can run afoul of the minimum wage laws. In Chicago, there's a minimum wage ordinance that right now it's $10.50 an hour, and it's going to jump to $13 by 2019. This, any of our people who are employed within the city limits of Chicago, they've got to get those increases, or the employers, whether it's UIC or whatever is there, Chicago State, they're going to be in a situation where they're going to be running afoul of the law. They're going to have a choice. Do we obey what the Illinois law has done? Do we obey the Fair Labor Standards Act? Do we obey the Chicago wage ordinance? They're going to find themselves in a real pickle in that situation. So I think that this concept that we can create this penalty of sorts, we can say that we're simply not going to allow you to make your future increases pensionable, is going to fall apart. It's going to create all kinds of problems. It doesn't work. And therefore, you really don't have a negotiated consideration-based agreement in these bills, and they're unconstitutional. Now, there are other parts of them that I also have issues with, issues that are going to happen to Tier 3 people. The big message is right now is that anybody who is currently employed needs to pay very careful attention, because this can have dramatic impact on when they're going to be able to retire, how much they're going to be able to retire with. In some cases, they may end up putting more into the pension system than they're going to get out of it in the long run. I just don't know, because I haven't seen what the new law is going to be when we get there. The real problem that I have as we get down to the end of it is that we're still going down this path of saying we're going to try to find a way not to pay pensions. So long as they're doing
not to pay it, but to pay less than they otherwise would.
It could be any of a number of things. The path that the legislature has taken, as it did with SB 1, is it said we want to find a way not to pay out the money. They're still on that path now. When it was SB 1, when it was Public Act 98-599, the State University Annuitants Association went out there and we said, we're going to fight it. And of course, as you know, you were there with me, I argued to the Illinois Supreme Court that it was unconstitutional, and the Illinois Supreme Court struck it down. Well, the message now is, if you pass another unconstitutional bill, the State Universities Annuitants Association is here, as I'm sure other groups are, although we've committed to it. We're going to fight it. And we're going to challenge it because it's unconstitutional as a diminishment. And the message really is, look, you're on this Grail quest. And what happens when the state goes on this Grail quest? They're not going to find the Grail, but what they are going to do is expend tremendous resources along the way. I spent a year and a half in litigation with the Attorney General's office. Some nice people. I enjoyed meeting them, but they're putting their resources into it. And what did it get them? It got them nowhere. Until the state gets to the point where it says we're going to look for a way to pay the pensions, we're going to look for a way to fund it, they're not going to be making progress.
I'll summarize maybe with this last question. Your bottom line argument, it might be, it's in the Constitution. If you need to cut the pensions, the only way you can do it is to pass a constitutional amendment that would allow you to override the existing Constitution. Is that kind of like we did with Prohibition?
You can certainly do it that way, although there are several constitutional provisions at issue. You're talking about the pension clause right now that says that membership in a pension is a contractual arrangement. I don't have it exactly right, but the benefits of which shall not be diminished or impaired. But I have to tell you that we also have a contracts clause. And again, the state will argue that they can turn around and ignore contracts. And I think that the law, as I argued to the Illinois Supreme Court, and I think the Illinois Supreme Court generally agreed with us, does not give the state the ability to simply ignore its debt obligations There's a whole line of cases on that. So you're talking about not just one, but several different portions of the Constitution that are going to be affected. In the last case alone, in SB 1, we had claims under the Pension Clause, the Contracts Clause, the Takings Clause. Somebody else had one under the Equal Protection Clause. I'm trying to think, there was at least one more in there that I'm not thinking of. So it's not such an easy thing to do when you're talking about amending the Constitution.
But you would have to do something, your argument would be, as dramatic as just amend the Constitution, and then your follow-up argument is that might not even necessarily fly.
I think that's right. I mean, put that way, I think that my view is that you've got a lot of steps, and I would have to see what the amendments are, and I think it's a very, very dangerous road to go down.
All right. Aaron Maduff, thanks for joining us.
Thank you.